Every time a Philippine president declares a state of national calamity, a familiar question echoes across social media and news headlines. Is this just another form of martial law? In this video, we're going to unpack the legal, constitutional, and historical layers behind this very controversial question. Is the fear justified, or is it just political noise? Let's find out. In September 2024, President Bongbong Marcos extended a state of national calamity, citing the severe economic and social impact of recent typhoons. For many Filipinos, this move immediately brought back memories of how his father, President Marcos Jr, once ruled the nation under martial law. It's no surprise that the comparison sparked a heated debate. It forces us to ask a critical question: how far can a president really go when using emergency powers? Let's dive into the legal frameworks that define these two very different, yet often compared, presidential powers. First, let's look at the state of calamity. Its authority comes from two main legal foundations. The first is Article 6, Section 23, Paragraph 2 of the 1987 Constitution. This section allows Congress to grant the president special powers for a limited time to deal with a national emergency. But the day-to-day nuts and bolts are defined by a specific law, Republic Act 10,121, also known as the Philippine Disaster Risk Reduction and Management Act. This is the law that gives the president the tools to respond to disasters. Under this act, the president can mobilize all national agencies and local government units to work together. He can also reprogram existing budgets, moving funds around to prioritize disaster response. A key power is the ability to impose price ceilings on basic necessities, which is governed by the Price Act, or Republic Act 7581. This prevents businesses from taking advantage of a crisis by jacking up prices. And finally, the president gains access to special calamity funds for immediate relief and long-term rehabilitation. So, think of a state of calamity as a set of administrative and financial tools designed to manage a crisis efficiently. Now, let's contrast that with martial law. The legal basis for martial law is found in a completely different part of the Constitution, Article 7, Section 18. This article is very specific. The president can only declare martial law in cases of invasion or rebellion, and only when public safety absolutely requires it. This is a much higher and more serious threshold. Under martial law, the government can temporarily suspend certain civil rights and allow the military to take direct control over civilian functions. However, the 1987 Constitution put in place strict safeguards to prevent the abuses of the past. A declaration of martial law can only last for 60 days. It requires the approval of Congress within 48 hours. And most importantly, it remains subject to review by the Supreme Court, which can rule on its factual basis. So, the key difference is this: martial law is fundamentally military in nature, designed for security threats like war or rebellion. A state of calamity, on the other hand, is administrative and fiscal, designed for natural disasters and other widespread emergencies. One is about military control, the other is about resource management. So if they are so different legally, why do people constantly compare them? The overlap lies in one crucial feature: the granting of extraordinary presidential powers. Both the state of calamity and martial law centralize decision-making in the executive branch and allow the government to suspend certain normal procedures. For example, during a state of calamity, procurement rules can be relaxed or bypassed. This is done to allow the government to buy relief goods and emergency supplies much faster, without going through the usual lengthy bidding process. Price controls, as we mentioned, limit the free market by telling private businesses what they can charge, and funds can be redirected from their originally intended projects without needing to go through the full, time-consuming congressional budget hearings. Historically, Filipinos have seen how these kinds of temporary powers, even when well-intentioned, can potentially slide into abuse. This historical trauma is precisely why the public instinctively draws the analogy to martial law. It's a fear rooted in experience. The issue of transparency further fuels this debate. Recently, a University of the Philippines law professor provided some important clarification. He noted that there is no specific law that forces the ombudsman or even the president to publicize every single decision made under a state of calamity. However, he also stressed that in a democracy, transparency is what builds trust between the government and its people. While the Constitution may not explicitly require the publication of all executive or quasi-judicial acts, the spirit of public accountability is deeply embedded in our laws, particularly in Article 11, Section 1, which states that public office is a public trust. This creates a gap between what is legally required and what is morally expected. The law gives leaders discretion, but their democratic duty demands openness. It's in this space between constitutional silence and public expectation that suspicion and fear can grow. Let's talk about the real risks and the safeguards in place. The main risks are clear. Over-centralization of funds creates opportunities for misuse or what's often called calamity. Politics, where aid is distributed based on political alliances rather than need. The ability to use negotiated procurement instead of public bidding can open the door to corruption. Deals may be made without proper scrutiny, but there are safeguards. Republic Act 10121 itself creates congressional oversight committees tasked with monitoring how the law is implemented. The Commission on Audit is mandated to report on how calamity funds are spent, ensuring financial accountability. And of course, a free press and active civil society groups play a vital role in monitoring the government's actions and raising alarms when necessary. These checks and balances exist, but they are only effective if citizens, journalists, and watchdog groups remain vigilant and demand accountability. Perhaps the most important distinction to make is the impact on civil liberties. This is where the two powers diverge most sharply. Under martial law, fundamental rights like the privilege of the writ of habeas corpus can be suspended. This means a person can be arrested and detained by the military or police without a warrant. During a state of calamity, your civil and political rights remain fully intact. You can't be arrested without cause, and freedom of speech and assembly are still protected. However, your economic freedoms can be limited for the sake of public welfare. For example, the government can control the price of rice or order certain businesses to operate or close to manage the disaster. The difference is one of scope, not necessarily intent. Both aim to preserve public order and safety. But one targets a security threat like rebellion, while the other targets the effects of a disaster. So, let's return to our original question. Is the comparison fair? The answer is both yes and no. It is fair in the sense that both situations demonstrate how a crisis can dramatically expand presidential authority, concentrating power in the executive branch. This is a valid concern for any democracy. But the comparison is also unfair, because martial law has a direct and severe impact on fundamental civil rights, while a state of calamity is primarily concerned with policy, finance, and logistics. The legal frameworks and safeguards are worlds apart. The key lesson here is not that emergency powers are inherently dangerous. They are a necessary tool for any government to effectively respond to a crisis. The real lesson is that these powers, no matter how justified, demand constant transparency and unwavering public scrutiny to prevent abuse. Thank you for watching. If you found this explanation helpful, please consider liking this video and subscribing for more breakdowns of our laws and rights. Stay informed and stay vigilant.